Hello, everyone. Apologies for the late start. My name is Chia Halpern-Butzel. I'm with the Tribal Law and Policy Institute, and I would like to thank you all for joining today's webinar, Tribal Domestic Violence Courts and Dockets, Foundational Elements of Domestic Violence. And today's presenters, I'd like to go ahead and introduce them. We have Bonnie Claremont, Victim Advocacy Program Specialist with the Tribal Law and Policy Institute, and we also have the Honorable Kelly Gaines Stoner, Victim Advocacy Legal Specialist from the Tribal Law and Policy Institute, and she also is a judge with the Seminole Nation of Oklahoma. I am going to turn it over to them right now, and again, thank you all for joining. And we will have time for questions at the end of the webinar, so if you think of any, go ahead and type them in or jot them down, but we will get to the questions towards the end of the webinar, so we haven't forgotten about you if we don't get to it right away. Okay, with that, I'll turn it over to Kelly. Thank you.
Thank you. Hello, everyone, and thank you for joining us. And thank you to Chia and Bonnie for being out there and participating as well. These are topics that we all feel very strongly about. And so we want to start off with some learning objectives, not only for us here at TLPI, so it kind of keeps us on track and reminds us not to get too far down in the weeds, because we do have some objectives we're trying to meet today. So let's go over these real quickly, and you can sort of keep these in the back of your mind so that if you have questions or you don't quite understand, don't think we've met one of these objectives, please ask us. So at the end of the webinar today, you should be able to identify the perpetrator. A lot of people will exchange perpetrator, batterer, defendant. We're going to use the word perpetrator today, the person committing the domestic violence. Identify the perpetrator's core objective, the number one goal in domestic violence cases, what that perpetrator is trying to achieve. Second, we hope you can identify, or you will be able to identify, at least 3 key barriers that American Indian, Alaska Native, and we're going to use that abbreviation there, that Native victims face in domestic violence cases in tribal communities. You should be able to identify at least 3 benefits of a domestic violence court or a domestic violence docket. We're talking about a tribal domestic violence court and tribal domestic violence docket. And identify at least 1 basic jurisdictional issue that may affect civil legal cases, DV cases in tribal court, and identify 1 basic jurisdictional issue that may affect criminal representation for the victim in tribal court. So with that in mind, that's our box, that's our parameter today. I'm going to turn it over to Vonnie, and we're going to get started with the presentation.
Okay, thanks, Kelly and Chia. So I want to discuss for a few minutes some of the foundational information that we talked about in the title, and I want to do that first by looking at some of the labels that are used for domestic violence, and we sort of interchange them throughout this presentation. As you will see in other materials that you may look at and so forth, but oftentimes the term domestic violence is used, but we also see domestic abuse. We may see interpersonal violence or intimate, what is it? IPV, and then also intimate partner violence, I'm sorry. And also family violence, which is one that I tend to not like to use because it implies that the entire family is being violent, and that's not the case when we're looking at cases involving domestic violence. Usually there's 1 perpetrator. And also at the core of this, or at central to this as foundational information, is perpetrators have a core objective in these domestic violence cases. And we'll show that in the power and control wheel, which is the next slide. And as you see, this power and control wheel has been used for many years, and I think it's a really good tool to use as you educate communities about domestic violence, and also even helping battered women understand why domestic violence happens, why the perpetrator is battering, because this wheel helps to has an image that's helps to facilitate an understanding of the batterer and what he's doing. So at the core of this, the core objective for the batterer is power and control. It's at the hub. It's at the center of the domestic violence that's happening. And so it's the hub, and the spokes are the tactics that the batterer uses and in order to maintain power and control. And on the outside of the circle are those offenses that are chargeable. So, but oftentimes all of the tactics that are being utilized, we don't see. Those are methods of maintaining power and control that's often done behind closed doors. So we don't see that part of it, but it's a way to keep the battered woman in control. So I want to just talk just briefly about the spokes and the tactics. Um, the batterer, the perpetrator, will use emotional abuse, and I'm not going to discuss all of them in a lot of detail, but ways to really put her down, to make her feel like there's something wrong with her, that she's crazy, that she's causing this violence. Um, may engage in some name calling, for example, or playing mind games. So it's kind of a more mental manipulation or brainwashing, I like to call it. Also using isolation because if she has outside contact, that's going to increase her support system, and he doesn't want that. He really wants to have sole control over her, and the less contact, the better. So he'll monitor all outside contact with her family, her friends, and really limit that. Even in terms of if she has an outside job, she's expected to be home by a certain time, and he'll question why she's not home when he thinks she's supposed to be home. Um, and also may use jealousy. So you're late. Who are you seeing? Who are you? I know you're seeing someone. You're talking to someone out there. So as another way of control and isolation, minimizing, denying, and blaming will make light of what he's doing and say, oh, that you're just making a big deal of nothing. We just did that, or you also hit me, or a lot of denying and blaming. um, or that she just simply caused it, that she started it, or she provoked the violence. The one thing that we really want to point out is how the batterer, how the perpetrator uses children, both to maintain control, threatening to report her to child protection as a bad mom or a bad parent, or reporting her for drug use, or and then even after she leaves, he may use the children as like pawns for using that time to harass her, the visitation time to harass her, which makes it really important that as these cases um, get seen in court, that the needs of the children and then also the behaviors of the perpetrator in terms of how he uses children is really addressed, so that the safety needs of both the mom and the children are addressed in those proceedings. And he uses male privilege. He does this because he can. Um, and he'll, kind of give the impression that he's the master of the house, the castle, and what he says goes, and treating her sort of in a subservient way. Uses economic abuse. He controls the money. He may give her a little allowance, or he'll question what money she does get and say, "Well, I just gave you $20. What'd you do with it?" And so he maintains that through economic abuse, which later makes it really difficult for her to think she can manage, because how is she going to support her children? How is she going to feed her children if he controls the money and if she doesn't have a job? Also using coercion and threats. Um, even to the extent of saying, if you leave me, I'll kill myself, I'll kill the children, I'll come and find you, I'll kill you. And more so, it becomes more volatile if she knows he has a gun or if he has the means to carry out the threats. Using intimidation, making her afraid by using looks, gestures, actions, even abusing animals. It's kind of a message to her like this. I'll do this to this object or to this animal, and it shows you what I can do to you, the harm that I can do to you. So these are some of the ways that the batterer, the perpetrator, maintains the power and control as far as the tactics are concerned.
And
Next
Bonnie,
slide.
I think it was one of the really powerful things that I think you said. I mean, they're all very powerful. I know you're an advocate, so you're in the field. You know how to use this wheel. You interview and screen cases to determine whether or not domestic violence is power and control is present in the relationship. But to those of us like the judge or the civil attorney or the prosecutor who may be on the outside, we won't necessarily be able to see all of these things. So that's one of the reasons that the tribal victim advocate is going to be a key person in identifying and screening whether these cases are even, whether it really is domestic violence.
Mm-hmm. Exactly. Okay, next slide. So, as long as advocates and others have done a lot of awareness building and education and training of professionals and so forth, there's still a lot of myths and misconceptions about domestic violence. And I think it's still really important that we continue to work to dispel these myths because they really undermine the battered woman's safety as well as her children, and doesn't, it allows the battering to continue by minimizing or not holding that perpetrator accountable by believing these myths and misconceptions. And such as that she's done something that deserves the abuse. She's provoked him, and he's such a nice guy, such a good provider, and she's just this nags him and is never satisfied, or she's out partying with friends, and somehow or another there's something she's done to deserve the violence. And of course, we all know that it's not the victim's fault when the battering happens. Oftentimes it's minimized. He just has his dad's temper, and he didn't mean to. It was an accident. Men are abused as often as women. We don't know that data. According to what we do know, according to the data, it's happening much more to women than men. So it's not to say that men aren't abused. Absolutely, they can be, and they are. But based on the statistics and the data, it's much more women than men. Victims are often questioned why they don't just leave, and we hear that all the time. If she doesn't like it, why don't she just leave? And we'll discuss this a little later. There's a lot of legitimate reasons why women don't leave, including some that I discussed on the power and control wheel. The brainwashing, not feeling like she can do this alone, especially if she has children. He's threatened her, and of course, she takes those threats very seriously. Leaving doesn't necessarily mean that things are going to all just be okay for her and her children. Sometimes leaving creates even more danger for her, and they say that leaving is really one of the most volatile times because, again, the core objective that he has is power and control. If she leaves, that's leaving him feeling like he's losing power and control. So he'll do whatever at all costs to regain that power and control, which is his core objective. And oftentimes we blame things like alcohol and drug abuse and stress. Oh, he's just overstressed. He's overworked. He works really hard, or he has some mental illness happening. And yet there are, we know that it's not, these may be contributing factors, that these might be things that are happening, but they're not the root causes of why domestic violence happens. It happens because of, the kind of society we live in, the permission given and the denial and, his reasons for wanting to have power and control. Domestic violence is a personal problem. People will say, I don't want to get involved. That's between the two of them, and I don't want to stick my nose in their business. We hear that often, but it's really important that intervention does happen because of safety reasons. And especially for service providers, for first responders, people who can offer some help and provide some safety for the battered woman and the children. there's this automatic sort of assumption that the victim's going to get custody. That's just automatic, and it's not that way at all. Oftentimes, as an advocate, I've seen battered women lose custody because she leaves. She leaves in the middle of the night because that's her only chance to escape the violence, and where she doesn't want to take the children because she doesn't know where she's going. And so she leaves them thinking she can come back and get them, but that doesn't often happen because he has the house. Maybe the house is in his name. He has the job, and when that is seen in court, then it looks like maybe he's the person who should get custody. There's a lot of battered women who don't have the resources to hire attorneys to regain custody or retain custody. So these are all misconceptions and myths that we need to really keep in mind in our work with this issue. There's a lot of statistics out there. I don't have a lot of confidence in any of them because I think there's still a lot of domestic violence that's not being reported. But by and large, what we know is that Native women are the most often battered, the most often raped. And according to some studies, that the perpetrators of sexual assault are non-Native men. And of course, that's going to vary from community to community. I've been in communities where they say no, it's men from our own tribe that's committing the sexual assault. So again, it's going to vary. But with this report, it says 86% of reported cases of sexual assault, the perpetrator was non-Native. So it makes it really really critical for us to look at our ability as tribes to have the authority to prosecute cases involving non-Native perpetrators who commit sexual assault crimes. And especially when we're talking about domestic violence, marital rape is a crime. And oftentimes it's not seen as that, or it's another assault that's happening or another crime that's happening that oftentimes gets overlooked because the woman herself may believe that there is no such thing as rape in marriage. It's just something you do. Okay, next slide. And any time where there's children involved in a domestic violence situation, absolutely they're going to be impacted. There's lots of studies out there on children who witness domestic violence, children who witness violence. We did some studies ourselves, and the statistics are staggering in terms of the children and how they're impacted. They could be physically assaulted by the batterer, as we see in this statistic, that 49 to 70% of men who batter their companion also abuse their children. That's a really high statistic when we look at especially the 70%. And so what it tells us is that safety is number one, that it's dangerous for children and their safety needs must be addressed through any proceedings. And oftentimes when we talk about children being impacted, they're impacted in a number of ways, both just feeling like, maybe even though they know that dad is battering mom, they still love dad. They feel like they still need a father in their life. They may have guilt because maybe they believe they could have helped mom and they could have intervened and protected mom. So especially for some of the male children, they feel responsible for the abuse that's happening. Next slide. And some more statistics. I'm not going to read all of these to you. We provide a lot of this just for your own information, for grant writing, or to do community education around this if there's some doubt about the seriousness of the crime of domestic violence, that you could use some of this data, and it's pretty current. While the domestic violence is happening, there's other crimes that are happening that might get overlooked, and I think it's really important that we screen carefully for these other crimes that are happening when we're working with a battered woman. Other crimes such as physical assault can be charged. Sexual assault, like I mentioned earlier, if he raped her, she still has the right, she retains the right to consent or not consent to sex with her partner. And if she isn't, if she's not able or didn't consent, then that can be investigated and possibly charged as sexual assault. Destruction of property, stalking. We see stalking crimes happen, especially after the battered woman leaves, that he'll continue to try to maintain that power and control over her by stalking her, showing up in, at shelters or at her workplace. Breaking and entering, if she moves and moves in with a friend or a relative, or even finds her own residence or her own housing, oftentimes batterers will break in and again wanting to see her or use the children as a reason to get at her. Child abuse, child neglect, child sexual assault. When I worked in shelters, oftentimes that was the time when children would disclose being sexually abused by the perpetrator, because at that time they felt like they were safe enough to do so. So when they would disclose, at that time, oftentimes they would, the battered woman would be accused of planting that information in the child's mind, when yet it's only because the child feels safe enough to disclose, and that's the reason why it happens at that time. Battered women may suffer the effects of domestic violence in a number of ways, and oftentimes have long-term trauma, because we're also addressing the how the whole person, how she's been traumatized, her whole person. It's not just a physical assault. And we used to say that if it was just physical, once she heals up and the bruises are gone, then she should be okay. But it goes much deeper than that. Like I talked about earlier, the mental, the psychological, brainwashing, emotional abuse that she's suffering, even the spiritual abuse. So there's any number of ways that she can be traumatized. And oftentimes this will result in her having difficulty in even thinking, concentrating, making decisions. And this is the time when, if they've escaped, maybe they're going to a shelter and they're not thinking real clearly, because they're, number one, they're just relieved that they're out of there for now and have a place to go where they can be safe for a bit. And it takes a while for them to recollect and regather their thinking and their thoughts. And this is probably not a good time to do a lot of questioning and filling out paperwork, but to give them a little bit of time to regain some sense of composure, where they can think. Sleeping problems, night terrors. If the assaults happen at night, it's going to be difficult for her perhaps to sleep. If there was strangulation, there's a lot of evidence that it can cause some brain damage, which may also contribute to her not being able to think clearly. Feeling lonely and isolated, he created that by isolating her. So, and then if she left and returned numerous times, her family are probably feeling like, well, why support her if she's just going to go back again? They have that kind of response to her leaving and going back. So she doesn't have a lot of support potentially because of that. She may also be feeling suicidal, like feeling hopeless over the situation. And economically, she may feel really challenged, because if he controls the finances, then how is she going to support her children? How is she going to feed her children? If she can't do that, what's going to happen to them? Will they be taken away from her? And then also just kind of losing hope, losing faith that things could be better. Next slide. Eating disorders. If the abuse happened around those circumstances, eating may become difficult, frequent absent from work, and we often see battered women being fired because either she is late or she is really preoccupied with what's happened with a domestic violence incident, maybe that just happened that morning or the night before, and she hasn't slept well. She has a hard time managing her work, and may get behind in her work. So there's a lot of pressure on her, and she may end up even losing her job. Anxiety, depression, anger, lots of emotions that are happening for her. And also frequent visits to the emergency room may also be present for battered women. makes it really challenging because, again, if there's children involved, who's gonna watch the children if I have to go to the emergency room? Um, those kind of factors. So rather than going, maybe just not and just tolerating the pain from the physical assaults. Next slide. Some more data. Um, And this again is the impact of on children who witness this domestic violence, who are exposed to the violence. And we all believe that children should be safe in their homes. It should be a place where they feel comfortable and not fearful. Um, and these are all contributing. The domestic violence is a contributing factor to many of these things. The poverty, the academic. We see a lot of children who have academic problems because, if mom and dad are hollering at night and he's beating on her, of course it's going to be difficult for kids to sleep, to think, to focus in school. So often they'll suffer academically. Um, so other types of impact and trauma that a child may experience. And today we're hearing much about suicides among our Native youth, and I often wonder if some of this is contributing to that sense of hopelessness and despair, that things aren't going to be any better. Okay. So we have to ask, why are these rates, the domestic violence rates, so high for in our Native community and in victimization? Next slide. And anytime I do education or trainings around any issues of violence, whether it be domestic violence, sexual assault, sex trafficking, I usually start with precolonization. How was it within our tribal nations? What existed there that prevented these things from happening? Because I think if we look at some of the solutions that we need to put in place within our families, within a court criminal justice response, we need to look at how can we weave in some of these values and customs and traditions into that response. We had strong traditional customs and values that, where there was gender equality. Our children were center in our families because they're our future. They were protected. We had our own natural system of child protection where we didn't have the need for outside sources to protect our children. We did that ourselves with our families, our extended families, and our traditions that extended our families. Um, we had a system in place. If someone was violent, there was a way that we responded to them. And crimes against or violence against women and children were egregious enough that the response was also very harsh. The consequence was also very harsh because women were considered sacred. Without women, the stronger the women, the stronger the children, and the stronger that unit, the stronger the family, and the stronger the nation. So it's all interconnected. And the mother-child bond was sacred, and was protected because of that, right from the very beginning. So it was important for everyone to really make that bond strong. So there's ceremonies that even involved strengthening that bond. So today, if we see that bond broken, it's really important. It's really critical for us to strengthen that bond rather than further punish the woman if she has some problems in parenting or if she has some alcohol, drug abuse problems. It would be really important to address those rather than bringing more shame or more guilt or blame to that mother for the problems she's having in parenting, but to strengthen that bond and work to empower the mother to be healthier and stronger as a parent. And it was any time a tribe experienced violence of any kind or a trauma, whether it's natural disaster or a death or whatever, the tribe came together and worked together to address that trauma. If the village was attacked and as a result maybe they lost some of their tribal members, they would come together to look at how can we help that family who's lost maybe their the father in the family. So they always pull together in a collective way, and I really believe that we still can do that because we lived on very little. We were able to expand our resources because we had little, but we were always able to look after each other and help one another in those times. So I think we can still use some of those same approaches and traditions to address the problem of domestic violence together in a coordinated community manner. Next slide. And these are, as we know, we can spend many hours and volumes of books and articles have been written on the issue of historic trauma. And so not only are we impacted by the current trauma that is happening, such as domestic violence, but it also raises the other past abuse that's happened, the historic trauma that's happened. I don't know where the bullet points went, but one of the things that happened is the diminishment in the status of women. When I said earlier, in our traditional times, there was gender equality, and women were considered sacred, and many of our nations were matrilineal and matriarchal, and women were leaders and seen as being very powerful and had a very powerful place in their families and their nations, and that's been impacted with colonization, where women have become basically like secondhand citizens. And we also look at destruction and disease that plagued our tribal nations, and boarding schools where our children were taken away from us and reared and raised in boarding schools where they learned violence. And then the different federal policies and that has impacted our ability to hold those accountable who come onto our lands and commit crimes. We're slowly regaining some of that kind of sovereignty, but that also impacted and increased the level of violence that happens in our communities. We talked earlier, I discussed earlier about why women stay or why they return to the perpetrator, and these are all reasons, and we probably can identify many more. There's some socialization that's happened where she believes that the children need a father. Maybe that's how she was raised with both parents, and she feels that's really important, and will do whatever she can to make that happen for her children. We used to tell battered women, a bad father is not better than no father. So until that person's able to get help through batterer re-education or some way for him to understand why he's battering, it's really dangerous for him to be there and dangerous for the children. Despite everything, she may still love him, basically. She may believe the myths, the blaming that's happened. She may blame herself for the abuse. She, as a result of some of that, she may have some low self-esteem. And despite anything, it's not her fault. He's made the choice to commit the violence, and he needs to be held accountable for that. He's made that choice, regardless of anything that's happening or regardless of anything she's said or done. He's still ultimately responsible for the choices that he makes. She feels that he can change, and if she just loves him enough and does the right things, that he can change and she can save him from any kind of criminal proceedings or anything else that they might face. She also may stay because of the finances. It's like, how am I going to support the children? I might lose them if I can't support them, if I can't feed them. And he's threatened that he's going to take the children, and she believes those threats. And we're often taught, not to put our business out there because of colonization. We're fearful of, not we're not very trusting of those systems that respond, whether it's law enforcement or the courts, and those are barriers that that many of the battered women face. It's like I don't trust that they're going to do the right thing for us, for my children or for myself. And you don't report your business to the cops. Um, and it's a huge barrier for battered women. So in the course of this, I want to say, and I don't know if I've said it enough, and I just have to say, safety is number one. Safety is always number one. When we look at working with battered women and their children, what is it? Where are you now? What will it take to help you be safe right now? Do you have a safe place to go? Do you have a safe place to live? Do you have family or friends where you can stay where you'll be safe? Would he know to go there to look for you? What all of those questions related to safety are really of critical importance. Safety is number one in our work and our response with for battered women. And also addressing her whole person needs. Like I said before, it's not just a physical assault, a physical violation. It's also mental and intellectual, where we need to look at how can we address that, how can we reverse that, where she's thinking it's because of something she's done, but maybe through the use of the power and control wheel, and to talk about things like male privilege in our society, to really take that shame and blame away from her, but to help her understand why domestic violence happens. And also to give her outlets, give her healing, healing medicines for her emotions, for her spirit. And we have many of that, many of those resources available for battered women, of course, at their choice. And also the physical part, to look at, does she need medical attention? Does she need to have a full physical, particularly if there's a strangulation that's happened that may be impacting her. So to look at the whole person needs, in wherever she may be reaching out for help. And victim empowerment is critical if we're going to reverse the tactics used in that, and the core objective of the batterer being power and control. We need to shift that power back over to her, to the locus of control back over to her, over her own life, and also to look at. In order for her to do that, she needs to have support. She needs to have good information so she can make informed choices, informed decisions. And some of those decisions she makes we may not agree with, such as her going back. And that's where things like advocates doing safety planning is really critical, to look at, okay, so you're going back, but when you go back, what do you need? What are you going to need to stay safe? Keeping a bag packed, having your paperwork close by you where you can grab it and leave, so you have your paperwork, you have your ID. Um, and so safety planning is critical as part of ensuring some safety for her if she does choose to return. And again, it's really important for us to not re-traumatize victims by putting that blame on her, by keeping her voice out of the decision making. She needs to be involved in the decision making. And as I travel across Indian country, I often see a lot of kind of the response to battered women taking on a more social service approach, and I really get nervous about that. That because of social services in the past have done things like case management. She's not just a case; she's an individual who has some decision-making powers over herself, and those should be respected. So she should be at the table when decisions are being made. Um, so that's important for anyone who's going to be working with her, so that we have a first do no harm approach to working with battered women. So we're not replicating some of the behaviors of the batterer by taking those choices away from her. And then all of this requires education at all segments of the community because, as community people, as relatives, we are all like first responders. It's not just law enforcement that are first responders. If a battered woman is needing some support, she may reach out to family or friends. So the community needs that kind of education. So, just to start wrapping it up, my portion of it, to recognize the high rate of domestic violence. And again, safety needs are priority for victims and their children. To honor the sacred bond between mother and child, to really look at, okay, what can we put in place to help the mother to address her needs for healing, for safety. And tied to safety is the issue of confidentiality. That's another huge barrier for battered women. I don't want to share what's happening with me because it's not going to be held in confidence. It's my business is going to be out there. I don't want to go to a shelter. He's going to know I'm there. He's going to know where I am. He's going to try to break in and get at me. So safety is really so closely connected to confidentiality. So we need to have really strict confidentiality policies in place wherever battered women may reach out for help. They may not have a lot of trust, and I talked about this earlier, and to really understand that in a lot of our tribal communities, as big as some of them are, they're still fairly small, tight-knit communities where everyone knows what everyone else is doing. And oftentimes, communities are very under-resourced, makes it much more important that we have a coordinated community response. So resources can be shared, information can be shared in a way that's still protecting her confidentiality as appropriate and as needed. Bottom line is that we need to hold offenders accountable and not to minimize the behaviors of perpetrators. Every victim is going to be different. The response is going to be different. They're not all the same. I've worked with many victims who seem very, very strong and capable, and yet inside they're hurting. They really do need help, even though they may not admit it. But being available to listen. So every victim is a little different. Their needs are going to be a little different. It's important to screen for what's most critical right now. And I always think safety is number one. And I already talked about the whole person impact and how the needs of children who witness the violence and how they may be impacted, and services that may also help them, child advocates, and also places where visitation can happen where he's not going to take the children or use that as a way to stalk the battered woman. Community impact, it's kind of like a ripple effect. It's not just something that impacts the battered woman, it impacts the children. Ultimately, it's going to impact the community. The healthier women, the healthier children are, the healthier the community is going to be. And also, if the batterer gets help, the perpetrator gets help and understands why he's battering and to change that behavior, I think that the courts can do a good job in addressing that aspect of it, along with probation and other programs. Next slide. Okay, that was my last. Now I'll turn it over to Kelly.
Thank you, Bonnie. Great job. Chia, I wondered at this point if you might want to talk about the evaluation that will be at the end, because I'm gonna move through this, but we don't want to get cut off to where folks don't know what they're supposed to do with respect to the evaluation. Chia, are you there? If not, I'll just tell you there's an evaluation at the end. So please don't log off until you fill it out. It's really short, and we would really appreciate the input. But Bonnie has just, I think, demonstrated just very, very well with her PowerPoints and her stories about how complex these domestic violence cases are, and that every victim is coming to us with some sort of trauma that we may or may not be able to see. And so it's so critical. I'm just going to underscore what Bonnie just mentioned about getting all of the system providers, especially when we're talking about a court, the judges, the court clerks, the bailiff, the prosecutors, the defense attorneys, the legal assistant attorneys, everyone, and hopefully there'll be an advocate there, everyone who's working on the case, even child protection, that everyone gets regular periodic trainings on these foundational pieces of domestic violence and how that domestic violence, according to that power and control wheel, may be manifesting itself. Another piece I think is really hard for lawyers, I can tell you this from experience, is victim empowerment. It is hard to sit there and give advice, legal advice to a victim, and then have the victim do the exact opposite. Because as lawyers, we really want to win. We want to win cases. And that's what we've been taught at law school, win, win, win. That's what makes you a good lawyer, a successful lawyer. Everybody fears you coming into the courtroom because you're a winner. And in these cases, they are different. And winning might just get someone killed. So we have to listen to what that victim's telling us and what that advocate who's working with the victim is telling us as service providers. Safety is the number one issue in these cases, and also holding those batterers accountable. That's going to be a huge piece in a domestic violence court or docket, as we're going to talk about in a few minutes. So as we move into the legal piece, I just want you to take a look at the types of civil relief that a victim may be asking for in the tribal court. So I just wanted to give you an idea. This is not an exhaustive list, but this is a list saying, I need a protection order. I got fired from my job. I got kicked out of the house. I don't have any money now. He's taken the money. I can't pay my bills. I've got debtors, creditors coming after me. I need a divorce. I need custody, and child welfare is involved in the case. So, and this is not an exhaustive list. There are so many others where a victim might need a very well-rounded lawyer who is either experienced in all of these cases or all this type of law, or a lawyer who knows other lawyers who are trained in domestic violence. And that is the key to come and assist with some of the client's civil legal needs. And as Bonnie said, they've often said a batterer or a perpetrator is not better than no dad at all. In other words, this is damaging the children. So the contact, even most of our state lawmakers around the United States have recognized that and put some presumption statutes in place where if there's domestic violence present, there's a presumption that the offending parent should not have custody. So let's, this is a huge complex issue that these cases cannot, a divorce with domestic violence in it cannot be treated like a divorce without domestic violence. They're just not the same at all. In the criminal realm, I'm talking here about like when a perpetrator, the offender, is being charged with a crime in tribal court, that victim still may need a criminal protection order. So we need our prosecutors to actually know how to draft those. Some do a really good job. Others really don't know that they can draft this no contact criminal order in such a way that it is recognized as a protection order. A violation of it is another crime. It's entitled to full faith and credit if that victim crosses jurisdictional lines. We need to have lawyers who know about victims' rights. That's been hugely impactful with the lawyers and their victims, the ones that I am working with, that those victims have their own lawyers show up in the criminal court and advise them what's going on, and making sure that their rights that are set out by statute or in sometimes even the Constitution are being protected. Also, there may be affirmative defenses that need, if the victim is charged with the crime, that she's going to have to bring forward. If the prosecutor wants her testimony, the prosecutor may want to talk to the victim about immunity, so she's going to need some advice on that, legal advice. And if the victim has been, and this is not uncommon, at least in the cases that we're working on, for the victim to have been charged, even pled guilty to certain crimes because that's what her lawyer advised her to do. So getting rid of those, getting those erased if possible. So we're looking at tribal civil jurisdiction and tribal criminal jurisdiction as we move through these cases. Also keeping in mind what Bonnie told us early on is that 86%, even though that will vary from region to region, we know from listening to some of the tribes that are exercising this special jurisdiction over non-Indians who are committing certain domestic violence crimes in Indian country. We're going to talk about that in just a few minutes. But we know that there are a large number of non-Indians committing these crimes against Indian women who reside in Indian country on reservations or on restricted lands. So it's critical that we know the difference, and jurisdiction can be a huge barrier for these victims as they're looking for help. Many victims that we work with, no matter what state they're located in, when this starts happening and when they finally make that decision to leave, they come home to their tribal community, their relatives, and they want to be able to access their tribal courts because they don't have to explain what the concept of a healthy family is with respect to that particular tribe. So as we run through this very quickly, this jurisdictional piece, I tried to break it down into 3 steps. It may or may not work for us, but in civil and criminal jurisdiction, step 1, what we need to do, and advocates can do this, it doesn't take a lawyer to do this. Take a really good look at your tribal constitution. Some of those constitutions were developed in the 80s or even before. They were boilerplate, handed out by the BIA, and they may have some barriers in the Constitution about issuing civil remedies, let's say a protection order, for example, to non-members. So you want to take a good look at that. Make sure there's no barriers in the Constitution or the tribal code. We want that to be clear, and those 2 documents to allow us as lawyers in tribal courts to be able to ask and receive, hopefully, protection orders from tribal court judges in matters that don't require tribal members to be before the court. We don't have to have 2 tribal parties. We can actually get the court to issue relief for other federally recognized Native Americans from other tribes and possibly even non-Indians. Number 2, if we're okay on that front, the Constitution and the tribal code, they're saying it's okay. The tribe, there's no restrictive language in there. The second question we're going to ask is, well, then has the federal government, either through Congress or the United States Supreme Court, has that body restricted this tribe's sovereign power to exercise this jurisdiction, whether it be civil or criminal? That's our second step. And if the answer to that is yes, then the next step is to look and see, well, if it was restricted earlier, has Congress enacted statutes that have loosened these restrictions? Because we all know before the federal government came to be, before the federal government became involved in Indian law issues, that tribes were pure sovereigns. They had the power to exercise jurisdiction over anyone who came within their boundaries, wherever those boundaries may be, even if those boundaries changed. And the people inside their territory, their jurisdiction, the tribal jurisdiction, would have to obey tribal law and custom, whatever that may be. So those are the 3 steps. That's our analysis we're going to look at today as we look at briefly, and this is, I'm saying very briefly, just scratching the surface of tribal civil and tribal criminal jurisdiction. We're not going to talk about PL 280 and state jurisdiction, and we're not going to really be talking about federal jurisdiction at all. We're going to stick with tribal today. So in civil matters, if I'm a judge here and I'm trying to determine, gee, you know, I'm a tribal judge for the Seminole tribe of Oklahoma, Seminole Nation of Oklahoma, and I'm trying to determine if I'm first going to look at my tribal code. I know that's not what the slide says, but it should. I'm going to look at my tribal code, my tribal constitution, and see, are there any prohibitions on me granting a protection order to a petitioner, a victim who is Cherokee and resides in the Creek Nation territory the Seminole Nation territory, and possibly a Seminole defendant. Is there anything in the tribal code or constitution that stops me from doing that? If the answer is no, then I go down to number 2, which is really number 2. Are there any restrictions put on me by the federal government? Has Congress or the United States Supreme Court put any restrictions on this sovereign power that the tribe has had since time immemorial? Let's go to the next slide. And we'll wait for the text. So we've asked the first question, and I'm assuming the tribal constitution and code are beautiful. However, we find some federal restrictions on a tribe's ability to exercise civil jurisdiction. And notice this title because it's kind of narrow. This came out of a U.S. Supreme Court case, and it's a tribe's civil jurisdiction over non-members on non-Indian fee land in Indian country. Wow, that's a mouthful. Indian country is usually it could be defined in the tribal constitution, but it's also defined in federal law. And if you're a reservation-based tribe, it's everything within your exterior boundaries. If you are a checkerboarded tribe, and not a PL 280, of course, but still, I think tribes have concurrent jurisdiction over in PL 280 states. But your Indian country, then, if it's checkerboarded, is going to be those pieces of land that the tribe owns and that are subject to some federal restrictions. Or the third one is a dependent Indian community. And you may have to, we have a lot of that happening in Alaska. You may have to get lawyers to help you get judges to hold that it's a dependent Indian community. But in any event, if the restrictions are going to apply, here's the way it applies. And again, it's non-members. I want you to think for a minute. When we talk about civil, we talk about members and non-members. We talk about member Indians who are enrolled in the tribe exercising jurisdiction, and non-members, which is a group that includes Indians, but Indians who are maybe members of another tribe and non-Indians together. So when we think civil, that's the group we're thinking about. And the United States Supreme Court says, if you have this fact pattern where there are non-members and whatever's happened has happened on non-Indian fee land in Indian country, you're the tribe that's exercising the jurisdiction, your Indian country, you have to meet this test. Or tribe, you don't have civil authority to issue a protection order, to do anything civil, divorce, custody, what have you. And this is the case. You can Google it, look it up. There are these two cases that kind of go together. If you go to the next slide, we see the test. Here it is. The parties have entered into a consensual relationship with the tribe, its members, through commercial dealings, contracts, leases, or other arrangements. You could argue that when two people enter into a consensual relationship and it's a tribe with a tribal member, that might meet the first Montana test. Or think about number 2. You only have to meet one of this. The conduct threatens or has some direct effect on the political integrity, economic security, health, or welfare of the tribe. Think about domestic violence. Does it affect the tribe's economic security? Think about that. Think about law enforcement coming to the scene, tribal law enforcement. Think about tribal medics coming to the scene. Think about all the ways the tribe is spending tribal money because domestic violence is taking place, or the health or welfare of the tribe. tribal sovereign's priorities would be to keep its citizens safe. So certainly this second prong is going to be met. And I urge you, if you're going to be rewriting tribal codes, you're going to be looking at all of this. I like the Tulalip tribe, also the Citizen Potawatomi Nation of Oklahoma. They have a really good purpose or legislative intent in their code that says, look, this domestic violence is an epidemic. They cite some national statistics. They cite some tribal statistics over the last 5 years, and they say, without a doubt, this has a direct effect on the political integrity, economic security, health, and welfare of our tribe. And we have never had a case go up that's had that in their tribal code. So just take that to heart, that may be very, very important in cases where you don't have two tribal members in front of you. And I think I take that very seriously as a tribal judge for the Seminole Nation, and you know, it's questionable whether they have checkerboarded land or reservation. That's being litigated, or will be litigated probably later. And I also want you to see the Violence Against Women Act, because step 3 was, has Congress changed this? Has Congress loosened this restriction that has been put on tribes? And if you read through this statute, it looks like it has. It says, for all purposes of this section, a court of an Indian tribe shall have full civil jurisdiction to issue and enforce protection orders involving any person. And if we skip on down, we say, and to use any appropriate mechanisms in matters arising anywhere in the Indian country of the Indian tribe. So we talked about that. And then there's another little section that says, or otherwise within the authority of the Indian tribe. And that second phrase may just mean, and I say may because it hasn't been litigated, that if you're a checkerboarded tribe and you can meet that Montana test, you have civil jurisdiction over any person that comes within your tribal service area, your tribal, what you're considering your tribal Indian country. It looks to me like what this statute has done, and I say it looks to me like that it has indicated for tribes with reservation boundaries. Now we know that those tribes, unless their own codes prohibit it, that this has really relaxed that restriction that was put in place in the Montana case. And now, if it's within a reservation, tribes can issue protection orders to any person, involving any person, which does not require tribal members. It can be any person. So hopefully that's not too confusing for you. It's again coming down to what is your Indian country. So let's talk about criminal jurisdiction. We've reviewed what sort of cases, what sorts of causes of action, that a victim might be seeking. And can tribes actually, if you get a PO, you're a victim and you get a PO in tribal court, can that tribal court enforce the protection order? And I think all victims deserve to know that. If it is merely a piece of paper and the tribe has no criminal jurisdiction to enforce it, they can only enforce it civilly, I think that's something that the victim deserves to know. So we know back again before the involvement of the federal government, tribes, again, pure sovereigns. They were exercising criminal jurisdiction over anyone who committed crimes or offenses in their Indian country. However, we know, and we also know that this inherent sovereign power, this full sovereign power, has been recognized and confirmed by the United States Supreme Court. There's just no doubt that it was there. So step 2, let's go to the next slide, says, has that been restricted by the federal government? And the answer to that is yes. There are actually 2 step 2s there, because there are 2 restrictions that Congress has placed on a tribe's inherent sovereign powers to exercise criminal jurisdiction. They cannot, it has been said in the Oliphant case, Oliphant versus Suquamish, that tribes they have no, their power to exercise criminal jurisdiction over non-Indians has been restricted. Even if those non-Indians commit a crime in Indian country, that power is restricted, tribal sovereign power. Step 2, we note, Congress has also placed some restrictions on a tribe's power, inherent power, to sentence a defendant in a criminal case. In other words, if I'm a judge and I'm sentencing, the defendant's been found guilty, I'm limited by a federal statute as to how long that defendant may be incarcerated. So now let's look on the next slide to see if any of those have been lifted. Aha, we see that yes, Congress has loosened in VAWA 2013 the restriction on a tribe's inherent sovereign powers. They have loosened that restriction that said a tribe cannot exercise criminal jurisdiction over non-Indians. However, they did it in a very controlled way, and its tribes may now exercise criminal jurisdiction over non-Indians who commit certain crimes within the tribe's Indian country if the tribe can meet the federal mandate. So as we look to this slide, that's what it's saying, and it really kind of gives you 3 crimes and 3 crimes only, although that can be a little bit deceiving because the tribes, depending on how their tribal code is written, can fit many more of probably their tribal crimes, criminal laws into these categories. So domestic violence is the first category, and that'll be defined in federal law. So, but even if the tribal code is different, if the tribal prosecutor is trained and brings the action and pleads it properly and demonstrates there is an intimate relationship between the two people and the elements of the tribal code are met, that can be prosecuted. The dating violence, that's defined also by VAWA 2013. It also requires, by federal law, the tribes are going to exercise this power, requires that to be an intimate relationship. What's really interesting is the third one to me, violations of protection orders for tribes. But look, tribes, these protection orders need to meet the requirement of VAWA 2013, and that's where the mandates are going to be set out. The protection orders also, the tribe had to have subject matter jurisdiction. They have to meet the VAWA full faith and credit mandates as well. That language has to be in the tribal protection order. And I just want to take a moment to give you, if you have a pen handy, pencil. If not, you can get on the chat box and ask us to repeat it. There is a resource at www, I have a terrible accent, but that is a letter of the alphabet, I'm saying, www.tribalprotectionorder.org. And that will, on that website, you will find all sorts of tips for drafting tribal protection orders. A lot of people want uniform, can't you just give us a form, a template? And I'm okay with some of the language being in a form, but every tribe in the United States is different. They have different laws, different elements in their statutes, different jurisdictional statutes, different remedies that a victim may seek in the tribal court. And I think those orders really need to be tailored, as Bonnie was saying, with respect to the particular needs of that victim. So while I'm okay with some of it being a form, it's very difficult to come up with one size fits all in a protection order for tribes. They're all so very different. And I just wanted to say we're going to talk in a few minutes about tribal domestic violence courts and dockets. So that's a nice platform if you are maneuvering your tribal codes, revamping, thinking about domestic violence, you're thinking about VAWA 2013 and special domestic violence criminal jurisdiction over non-Indians. Think about, look in a little deeper about domestic violence courts and dockets. Oftentimes, it won't require an enormous amount of resources. And what those courts are going to do are focus on victim safety and batterer accountability, just as Bonnie was speaking about earlier. The second restriction placed on tribes, you'll see here what it is. This is the restriction. Tribal courts cannot impose conviction for any one offense, any penalty or punishment greater than a term of 1 year or a fine of $5,000 or both. That's what a tribal court can do for rape 1, for murder 1, for habitual domestic violence offender. That's it. Unless, here's the relaxation here, under the Tribal Law and Order Act. There's the citation where you can Google that and it'll come up. the TLOA, TLOA we call it, actually amended the bullet point right above and said tribes that want to exercise enhanced sentencing, we're going to relax that restriction we put on you, on your sovereign powers, and now you may incarcerate for up to 3 years and or fine up to $15,000. And if you max and stack, I want to say it's 9 years. That's where you're adding different crimes that occurred in a series. But again, to do this, there's a loophole, and it says the tribe has to meet certain federal mandates. And so we're going to give you some resources here at the end that are going to show you what those mandates are. Now, if a tribe says, look, we don't have the resources for this this increased sentencing, we don't have the resources, we don't have a detention facility, we don't have the money to pay the county, the state, or another tribe, so we want to just stay with the first bullet point, that's fine. But it is an opportunity, it is a relaxation of one of the restrictions placed on tribal courts, tribes, and just know it's there if you want to work towards implementing the TLOA. And also, domestic violence courts and dockets may be a useful platform for that as well. And we're going to talk about why when we get down to the resources. So let's talk about these DV courts and dockets, and I'm going to go really quickly because we're going to run out of time, and I did want you to have some time to ask questions if you want. Let's go. The focus of this court, as I said earlier, is safety of the victim and the victim's children, whether that's a man or a woman victim, and to hold perpetrators accountable. That's the sole purpose of the domestic violence courts. It strengthens tribal sovereign powers. It enables the tribe to keep its citizens safer. It allows for, through the development of codes and tribal court policies, to incorporate tribal customs and traditions, how a tribe feels about what it takes to make a family healthy, what a tribe did historically to make these sort of corrective maneuvers for a family that was experiencing these sorts of issues. All of that can be addressed in a domestic violence court. It also allows the court to implement policies, protocols, trainings. That's a huge piece that Bonnie talked about for personnel that come in contact with this family. Because for the sheer reason that Bonnie pointed out in that power and control wheel, you can't always see this. You may not know these people. And I know that tribes that have tribal judges that are from their community, that are tribal members, they may understand and know what happened long before the legal attorney gets there. They're familiar with the families. But if you have tribal judges that are members of other tribes, that are in Oklahoma, we sort of have circuits and our judges ride from one tribal court to the next. They may not necessarily know what the tribe's customs and traditions are. And here's the opportunity to get back in there and say, wait a minute, this is what a healthy family looks like to us. We want you to be trained on not only those foundations of domestic violence, we want you to be trained on what a healthy family looks like to us and what our tribe feels is best for families. And it also helps build those strong partnerships that Bonnie was talking about, that collaborative approach that victims and their children so desperately need in order to really effectively address domestic violence. These courts may handle civil or criminal cases. They can handle a combination of both. And we have some handouts here at the end that'll kind of give you some examples, but the sky's the limit. You can say, we're just going to do protection orders, or we're just going to do protection orders in violation of protection orders. The tribes will pick what is most needed for their tribal communities. Also, these courts put the focus on victim safety. Here's how they do it, just some of the ways. They stress early intervention, early screening by the advocates, keeping those victims informed, keeping that advocate an integral piece of the team that's working on the case to make sure safety is always being addressed. And it also focuses on court safety. You know, within the last 6 months here in Oklahoma, we've had one of our state attorneys murdered. It was a homicide, and his client was murdered, and she was a victim of domestic violence, and then the perp was on his way to get his attorney as well after a day in court that probably didn't go like the perp wanted. We need safety in our courtrooms. That victim needs safety getting there, getting back, and that advocate's watching to see how that case went. If the batterer is showing signs of agitation, this advocate's changing the safety plan, and it really should help judges focus on the ramifications of the orders they are issuing. Is the order going to put this victim in even more danger? And I'm going to need the advocate to help me understand that with lethality assessments and things like that. So it's getting this team together and everyone's on the same page with respect to their education and understanding of the dynamics of domestic violence. Let's go to the next slide, please. Within the realm of holding batterers accountable, it's so much more difficult for a batterer to manipulate if they're having the same judge every time and the same team working on the case, and everyone has heard the court orders, they've seen the batterer's behavior, they know the batterer's tactics, and they're able to recognize those and say, you're not going to get away with that here. Because oftentimes that batterer comes into court and is so articulate, velvet smooth, and the victim is looking very shaken, very traumatized. Sometimes the victim doesn't even appear because the batterer has prevented the victim from appearing. So we need everyone to be on the same page and to hold the batterers accountable. And again, systems working together, child welfare, victim advocate, law enforcement, judges, all of those folks being together, agreeing on a policy on how to handle these cases, and following up, probation, following up on whether the batterer has done what the court assigned the batterer to do. There'll be review hearings to see if the batterer has achieved what the court has ordered, and if not, there will be accountability. Remember, all of this is taking away what Bonnie pointed out was at the very center of that wheel. It's taking power and control away from that perpetrator and giving it back to the victim and providing the victim with services if it's working properly. Next slide. Okay, I've already talked about that, so we can go the next slide. And if you're thinking DV courts sound too much, you need to do something right away, you don't have the resources for the court, think about a DV docket. And as we look through this is a lot of the same information, except you may or may not get the same judge. This is setting aside a particular day of the week or the month to handle the DV cases, so that on those days, the victim advocate knows she needs to be present. We've got safety plans for getting the victim to and from the courts safely, and hopefully we've got some bailiff who understand things happen in the parking lot after court, so the bailiff is on high alert, law enforcement's on high alert, and hopefully we've got a trained judge, some trained court personnel. A domestic violence docket is better than having nothing at all. It truly is, because of the safety piece that we can put in here. Next slide. Okay. And I think we have maybe about 8 minutes. Chia, do you want to come back on and talk about the evaluation? Do we have any questions for either Bonnie or myself?
Can you hear me now?
Yes.
To make sure okay, good. Okay. So I don't believe that we have any questions. Earlier, someone did ask if we would send the slides out afterwards, and we will probably send those out on Monday after we can review it. And we have a couple documents that we will send out to the group as well. And again, we'll send out, or at the end of this webinar, when you close down the webinar, a little short survey should pop up. If you all could please answer that, that would be great. Right now, since there's no questions, I'm just going to go ahead and go through the rest of the slides that show some resources that we have and let Kelly explain those, and then we'll turn back to, I'll go ahead and interrupt if we happen to get any questions. So for those of you that are attending, if you have any questions, please feel free to type those in right now.
Okay, we wanted to put together some resources. This by no means is all of the resources that we can provide, and please reach out to us at TLPI if you have any questions at all. We have, these are free. They're downloadables at PDF on the TLPI website, and that's excuse me, that tribal-institute.org. Chia, is that the website?
Right. So the resources right now, we have some, you can look on tlpi.org, or on our home site, we have a number of the resources up. The website there, home.tlpi.org. Someone just asked, is there a TA available for tribes wanting to set up a DV court or docket? And I say yes.
Yes. I think they would
contact us.
Sure. I think that's what needs to happen, and we'll run that through Jerry Gardner, who's our executive director. We do have a grant. We're working on putting together some materials, resources for tribes that want to develop tribal courts and tribal court dockets. I think that's what that middle resource is, and I can't see it really well on my computer because my internet's not working very well. But also this pink book I love, because it talks about domestic violence laws. And if you are wanting to go back in and redo your code, these laws are victim-centered. It's got a whole piece on victims' rights. If you're thinking about TLOA and this enhanced jurisdiction over non-Indians, you're going to find that in the green book over here. And these are set up like workbooks. And it'll really ask you to get a team of people together, give you some suggestions of who should be on your team, and you work through these as workbooks together. And hopefully the product at the end is really what is a reflection of what the tribal community needs. And again, those are
here are some the worksheets. Kelly, I don't know if you want to briefly go through it, but we are going to send these out to everyone along with the PowerPoint slides on Monday.
Right, just fact sheets on domestic violence, tribal domestic violence courts, because this is, some of you may not have thought about these courts before, and also the tribal domestic violence dockets, just kind of the difference between the two, the benefits, the barriers you might think about, why they're important, and so hopefully you'll find those helpful as well. And this is just our website on here, and you'll see, I think this is the Violence Against Women Act. This is the VAWA pieces, and you'll see the little blue links. You can click on there and download those. And these are the pilot tribes, the first tribes that began to exercise this special domestic violence criminal jurisdiction in Indian country. I think, do we have 17 now tribes, Chia, that have implemented across the United
17
States?
that we know of right now.
17, and they also are a member of the ITWIG. It's called the Intertribal Working Group. It's free. We meet by phone once a month. We have face-to-face meetings that we attend about every, I think maybe 2 a year, and it is just a think tank, and there are just some brilliant people working in Indian country there, and they're discussing any issues they have coming up, any issues that arise as they're implementing or exercising TLOA and special domestic violence criminal jurisdiction. And look, they will share their forms, their jury verdict forms. This is just the most wonderful resource, this ITWIG group. And you can join for free by emailing Chia, is it vdavis@ncai.org?
Yes.
Or Chia, and Chia at tlpi.org. You can get on that mailing list, and you can tap into all of these resources to take a look and see, well, what are other tribes doing? Because again, they're doing different things. They're doing it their way.
Okay, we got another question, Kelly. How does this affect the individuals as far as DSCF and paper trails created that could infer that both parents, including the victim, are putting the children in danger or child abuse, considering their main concern is the safety of the child?
Okay, so I'm getting intermittent interference on my computer. So I think what you're asking me, I didn't understand the mnemonic or the abbreviation, the D.
Yes, I'm not sure. And maybe it's like the acronym, maybe Department of Safety and Child Welfare in their state. I'm not
Okay.
sure.
And so ask me again, and we'll assume it's child welfare. So ask me the
Sure.
question.
Okay. How does this affect the individuals as far as DSCF and paper trails created that could infer that both parents, including the victim, are putting the children in danger or child abuse, considering their main concern is the safety of the child?
Right, and that's a great question. And listen, I just want to say, and Bonnie can weigh in on this as well. We are all trying to get to the same place. I mean, I hope that all of our goals are to keep victims safe and their children safe. I hope that's our goal. How we get there, we see a little bit differently, and we see through the lens of whatever discipline we belong to. I see it through the judge's eyes and the civil legal attorney's eyes or a prosecutor's eyes. I don't see it through social work, and I don't see it through an advocate's eyes. So we're seeing through different lenses. And so one of the things that's great about a DV court is you're really going to have to sit down and have a face-to-face meeting with the advocate and the other members of the team, and you're going to have to say, what are our policies and protocols? What should they be? Can we agree upon a way to do this that we all can live with, that we all can keep within the parameters of either our grants or our funder or our mission statement? And some of the things, I'm not telling you by any stretch of the imagination that in all cases the children should never be removed. Sometimes the children are in danger and they need to be removed. But far too often, that seems to be the knee-jerk reaction, is remove the child because domestic violence is present and we'll work on the rest later. And we are learning, and we're hearing over and over and over in Indian country, if you can keep the batterer away and the victim safe and give her time to rest and heal, that is so much less traumatic for the child than removing the child from the non-offending parent. Now, I understand there are going to be some times when you have to. I get it. But we could come up with some guidelines and we could work that out. I think we could if we keep going back to the same goal. And that's what's so critical about a DV court, is that's what you're going to do. Law enforcement's going to say, this is what we're going to do. These are our policies and protocols. We're going to call the advocate out first. We're going to have the advocate do a lethality assessment, or we're going to do it. We're calling the advocate. We're getting all this taken care of. We've got a protocol that we agree on that's best for both the child and the non-offending parent. I see we've gone over about 1 minute, so I didn't know whether we need to get off or whether Bonnie wants to say a word.
No, I'm good.
I'm just going to scroll through the next slides very quickly and leave it to Bonnie.
This is that checklist that we told you about. This is so great. It checks, and I love the way the checks come in and out. It seems so fancy. The checks are required by TLOA and by VAWA Section 904, the criminal jurisdiction over non-Indians, and you'll notice most of them are the same. So if you do one, maybe you could consider doing the other. There are some differences, usually the jury trial and some of the other pieces, but I wanted you to see how close they are with respect to the federal mandates. And with that, I'm going to turn it over to Chia and Bonnie.
We just got one comment that says, I would think that ideally a tribal court would include an MDT that includes child welfare professionals trained in DV.
Yes, some tribes have them, some don't. Some have a coordinated community response. Bonnie, you're an expert in that area. Do you want to comment on that one? That's really going to be the approach for the DV court.
Yes, that would be of maximum benefit, but it's not happening in every tribal community. Again, like you're saying, it really varies across the board with tribes and based on their resources and so forth. But that would be most beneficial if we could get child welfare involved in coordinated community response. That would be great.
We probably should wrap it up. I'm listed the contacts here with Bonnie and Kelly's email if you have questions for them. If you have any further questions, you can email them or myself. My email is chia@tlpi.org, and I will send the PowerPoint and the fact sheets out to you all on Monday. And thank you all for joining. Kelly or Bonnie, is there any last words that you all have?
I just want to thank everybody for joining as well. You can tell we're all very passionate about this topic. And thank you all for taking the time to spend some time with us on a Friday afternoon and listen.
I agree. Ditto what Kelly just said. And give us your feedback if you can. Thank you very much for joining.
Thanks, everyone. Have a great weekend.